If use of intellectual property is made freely available, then it would destroy the desire to invent. Intellectual property is undeniably a modern notion. When I say modern, I mean in comparison with the traditional genres of property as it has always been understood. It is a law which rewards and protects the ownership. In India, one had a really anti-ownership approach over knowledge and creativity. Knowledge had to be shared. There were no fences built around what is known as intellectual property. There were identity indicators, as in signatures of poets, Meera Dasi, Janam Janamiki, or Kahata Kabir, whatever. But it was not to say verboten to those infringers. It was just plain signature. There was no ownership to the creation. But the law of intellectual property has come to stay, and so has the law relating to it. But it is not easy to grapple. The growth of information economy, an economy built on intellectual property, is so phenomenal that the legal system which does not recognize the importance of this branch of law will fail because of the sweeping impact of these property rights, transcending all physical barriers, not even of the physical world which we inhabit. This law is a bit quirky, and persons who have to deal in this law either as owners, trespassers, judges, lawyers, or scholars often find themselves without a compass to point the right direction. The new technologies only add to the disorientation. With the transformation caused by internet revolution, questions have arisen regarding the abuse of the system, which may reduce its effectiveness. Law has not yet fully caught up. We just now heard of posthumous IP management. So it slightly lags behind the pace of the technological growth. For instance, works can be viewed, copied, reproduced, displayed, and distributed by new technologies, in particular the internet, and this naturally affects the copyright owners. The cost of making and distributing copies is almost nil if you compare the expenditure that's incurred in making hard copies. In American Geophysical Union versus Texaco, the publishers of scientific journals said Texaco copied articles from journals and then distributed to its researchers, and that it was infringement. The Second Circuit held against Texaco. Texaco applied to the US Supreme Court, but there was a settlement there. So there was no real ruling by the Supreme Court if that practice was infringement. The Second Circuit's holding that it was remains. Some persons gloomily predict that the IP regime will only work to the disadvantage of India. The fear that products which are unique and indigenous to India, just now we heard Mr. Chandrasekhar speak of turmeric. People feel, the Cassandras feel, that this will be appropriated by other persons, which would deny the maximum utilization and benefits therefrom by India. The gloom is perhaps unnecessary. After all, it is the law users who make the law, good or bad. Even our constitution is not good or bad in itself. It's how we work it that makes it so. By improved awareness, by effectively asserting our rights, by efficient adjudication to protect their rights, we can make the IP regime work to our advantage. The 3 A's, awareness, assertion, adjudication, determine the growth of our economy.